All due respect, like I said, I don't have anything personal against this court. I'm not a corporation, right? I'm a natural person. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard testimony.
Here is a single paragraph fully rewritten and completely original with clean language and clear courtroom commentary. Tone: a self-described sovereign citizen entered the courtroom with a confrontational attitude and showed little effort to remain calm. He repeatedly interrupted the proceedings and ignored basic courtroom decorum. The reason for his appearance stemmed from driving without a valid license, as if traffic laws did not apply to him. What stood out most was the judge's response, which was firm, measured, and unexpected. The way the situation was handled shifted the entire tone of the hearing. Rather than escalating the moment, the court maintained control and clarity. The exchange quickly revealed how poorly prepared the defendant was. The following footage captures how this hearing unfolded and why it became such a memorable courtroom moment.
All due respect, like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have to be charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Cheney versus Winnebago Department of Social Services, there was a young child whom the mother alleges that the father was beating the child, and the child died. The mother sued all the way to the U.S. Supreme Court. And the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor. And I ask that this court, do their sworn fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever. Like the great honorable Judge Dalton A. Robes. So every government is entitled to a Republican form of government, not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default. I just ask that this court dismiss this case at this juncture. If the court does not, I demand under the supremacy clause, the subpoena power of this court, to have Kim Worthy brought in so we can have an evidentiary hearing. Because how can a criminal prosecute or allege that I'm a criminal when they're committing all the crimes, Judge? Since I've been home, I've been making reports of police and other things, violations of law against me at the precinct. And no one listens to me. They just ignore me. But when people call and say, well, hey, Mr. McCray did this, Mr. McCray did that, they come, then it's found out nothing happened.
Under our state constitution, this court has jurisdiction. Furthermore, as far as discovery goes, I personally sent Mr. McCrary twice, and I have the emails, copies of the emails to show that that's necessary.
Where are the dates?
Dates are not on here. May 24th, which was last week, and May 5th.
Here is a single paragraph fully rewritten and completely original with clean language and clear courtroom commentary. Tone: the defendant reacts with visible disbelief, as if recent communications from the prosecutor never existed. He remains firmly committed to his position despite clear contradictions in the record. The confidence displayed does not align with the facts being presented in court. While the statements may sound unreasonable, they are delivered with complete certainty. This level of persistence stands out even when every point is addressed and corrected by the judge. It highlights how firmly some individuals cling to personal beliefs regardless of evidence or explanation. The hearing becomes less about legal debate and more about refusal to accept reality. This moment shows how dedication without understanding does not change how the law is applied.
I'll give you, it's gonna take a couple seconds. One of those emails, he is Michigan in there.
That's not my fault. They violate your order. Yes, ma'am.
Okay. So you should have received one of them.
Nothing.
Right, and neither one of them came back as a bad email.
Okay. All right, so Mr. McCurry, I don't know why you're not receiving discovery, you did not receive it.
He didn't send, can we subpoena Google and,
No,
litigate this and
This
show that he hasn't
this
sent
is not a
anything?
trial, this is not evidence you're hearing.
Well, can I say one more thing?
After we get done today, confirm your email address, you can send a test email to make sure that he received it.
Well, he did. It showed me that he got my paperwork. He admitted in the last receipt that he received my
Okay,
paperwork.
and
So why would he send it? Well, why wouldn't I get it back? My email is legit. It's my phone right here.
okay.
Also a jurisdictional challenge.
Let's,
Right?
before we get to that, AJ intercession, if you want to respond before we proceed.
Yes, Your Honor, I do want to make a record. You know, this defendant has already availed himself to the jurisdiction of the courts of the state by admitting to having a driver's license. And also further add that the 10th Amendment has allotted and given police powers to the state, which then allows the state to create criminal laws under which this defendant must avail himself to. I further add that, again, as the court has acknowledged, that this defendant has at least once received the discovery to his emails, to his correct email. So any more allegations of not receiving discovery would be improper, given that we have it at least proven that he has it at least once. And there have been no additions or corrections since the discovery was done the first time.
Okay,
May I
Mr.
respond?
McCurry, I'm gonna wrap this up, you can respond and.
Yeah, just briefly if I may.
Sure.
Well, this young lady here to basically
Mr. Sessions,
respond, Mr. Sessions, to respond to her statements in Michigan. They're locking people up for not having a driver's license. I was compelled.
there are people getting
But I
locked up
reserve
for-
my
for
rights. This was the
murdering
law.
people as well.
Pardon?
People getting locked up for murder as well.
Well, I understand that, but what I'm saying is the corpus delicti, they're going off written statements. You know the corpus delicti rule under the Michigan Supreme Court case, as well as the federal court case. Where's the body of a crime? They're saying ammunition, all this, that. Where's the guns at? Where's the victim at? Strangulation, where's all this? Where's the medical?
I wouldn't know because we haven't
And
had an
then,
exam.
okay, but no, jurisdiction, once it's challenged, it must be proven by the people. This is state and federal law, judge from the Michigan court.
Here is a single paragraph fully rewritten and completely original with clean language and clear courtroom commentary. The defendant's behavior creates uncertainty about whether the actions are intentional delay or genuine misunderstanding. At times the presentation sounds calculated and controlled rather than chaotic. He speaks confidently and references legal ideas even when they do not apply to the situation. That delivery can be misleading to casual observers. However, confidence does not equal correctness and the arguments do not match the stage of the proceedings. Claims about victims or evidence are premature and misplaced. The prosecutor has already established the foundation of the case. Repeated interruptions only slow progress and weaken credibility. What becomes clear is that extended speaking does not improve the outcome. The hearing moves forward based on law and evidence rather than prolonged commentary.
So I'm demanding that I mean, they're already in default, but still again, I'm demanding jurisdiction be challenged, personal subject matter and territorial jurisdiction. Even when I was in prison, I had interactions with Kim Worthy, chief prosecuting officer for the state, and I reserved my rights in prior proceedings, as well as I was compelled to obtain a driver's license, and I reserved my rights. That's all the law mandates, that I reserve my rights, which I have done. And right now, this lady, Mrs. Prosecutor, I can't remember her name, and Mrs. Sisson, Esquire Sisson, and this gentleman here, they're in conspiracy and violating federal and state law. They're committing crimes, and I demand that their oath of office, their law, their license to practice law, amongst other things, be given to me, as well as their bond, as well as you, Judge, Your Honor. Also, like I say, jurisdiction has been challenged, and they have to prove it first based on the case law, which I have noted in this paperwork. They can't get around that. We can say, well, yeah, they're talking about reserving rights and all that. Okay, but still the law from the state Supreme Court, Court of Appeals, and federal jurisdictions clearly mandates that once jurisdiction is challenged, the person asserting jurisdiction has to prove. And all they have is statements. Under the corpus delicti rule, out of court statements is not evidence, so these charges should be dismissed. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard testimony to know.
Well, that's not how it works with jurisdiction
Well,
challenges.
that's how, you know, that way. So, do you have any last
Well, I would like,
statements, because I'm ready.
okay, I would like to challenge jurisdiction again, which I have done from the onset of this case. Personal, subject matter, and territorial jurisdiction. State and federal case law is clear. in which this court being inferior to the higher courts must adhere to their oath of office, their bond, and so on and so forth, their license to practice law and the Michigan rules of code of judicial conduct, and must compel the people to prove jurisdiction, which they're asserting. Where's the proof? You have to show this court. That's at any stage of the proceeding, the law allows that.
Okay. So on discovery, I saw paperwork confirming the email address that you provided to the court is now the record, that discovery was sent. I'm not sure if it was an email, please tell me if there's another email you would like to be sent to, I will ask the prosecutor to do so. 2, for requesting license numbers from everyone. My name is right here in front of you. You can go right on State
I ain't
Bar.
saying nothing.
RP numbers are available for you to look up as they are for any general public, okay? As far as venue, jurisdiction, and you mentioned this, you don't know whether I was appointed or elected, I was both.
Here is a single paragraph fully rewritten and completely original with clean language and clear courtroom commentary tone. This is exactly why court proceedings can feel so slow and frustrating. The system is designed to follow procedure carefully, but individuals who waste time with irrelevant arguments only make it worse. Real victims and cases get delayed while the court addresses unfounded claims. Basic laws, like the requirement to have a driver's license, are ignored in favor of imaginary loopholes. What stands out is the confidence with which some people argue, even when completely wrong, refusing to acknowledge reality. Their actions never succeed and only make the situation harder for themselves. Support from like-minded peers encourages this behavior despite the consequences. Some may genuinely believe their arguments, while others may simply be testing the limits of the system. Either way, the result is the same: time wasted and legal trouble increased. Viewers are encouraged to stay informed, engage respectfully, and follow updates as cases continue.